This is the second screenshot video for weeks 3 to 4 in the Intro to Law course. We are talking about the sources of the law, and in the first screenshot video I identified all 5 sources and then went through the constitutional source or constitutional authority. I then mentioned judicial authority and made the significant point that judges in the American legal system make the law on occasion. And at the end of our last screenshot video, we had talked about how judges create legal rules when they interpret the other sources of legal authority. The second way in which judges make the law or create legal rules is when they engage in the common law process. And I think it's useful to first begin with some history as to how it came to be that judges historically created rules of law. And as I point out, the common law began in a way in 1154 in England, a few years back then, under King Henry II. And what the king was faced with, what the crown was faced with, was the need on the one hand to have some kind of a system in which legal disputes get resolved, and on the other hand to be aware of the fact that in 1154 and quite frankly for some time after that period, there really wasn't a viable, or if you will, an effective legislative body in England. So the king sends out the judges, and they travel the realm, as we like to say, and people. So as I said, people involved in legal disputes would appear in front of the judges, and the judges would resolve the dispute, as I put, on an ad hoc basis. Now, what were the judges using to decide those cases? They were probably turning to custom. They were probably turning to practices followed in different commercial settings. By 1154, a mercantile class was beginning to form in England. There were traders and so on. The church would have been a source for some rules that the judges could apply. But what eventually happens is this: we've got judges making decisions, and there was no guarantee that a decision made by Judge A would be even known in another case heard by Judge B. But then a couple of things happen. Number one, anytime you get a legal system, it seems that you attract a certain group of people, attorneys. And so now you've got, at least in some instances, individuals with lawsuits hiring lawyers. And then the second thing that happens is that you also have, certainly by around 1500, the printing press. So it's a lot easier to reproduce documents. And then there comes the day when the decisions are recorded and judges began to follow the decisions in past cases, which were now available and brought to their attention by none other than the lawyers, in deciding the cases before them. In other words, by following the past cases, the judges gave the imprint of the rule of law on the past cases, and we could say then that a body of law becomes or comes into existence known as the common law. And what's interesting, it seems to me, is that the common law is not simply something that once was. It was a featured part of the American legal system as the years went by. It migrated, if you will, to the New World. And even today, although we have viable legislative bodies that one would think are creating most of the laws, the common law still does exist. And we're going to make a couple of more comments about that a little bit later on. But for now, let's make certain that we nail down that the common law is state law as opposed to federal law in the American system, so that the common law of the state of New York is not going to be identical in all respects with the common law of Vermont, but one would think, and indeed one would not be surprised to find that they are substantially similar. Another point to keep in mind is that today, and actually by the time the common law came to the United States with the colonies, the legislative branch, and this was certainly the experience too in England, the legislative branch, which now is viable, unlike when the common law was in its infancy, can eliminate the common law by way of legislation. And I point out that typically when the legislative branch does this, it marches under the banner of reform. It's claiming that the new legislative rule, which is changing or eliminating in the process a common law rule, is accomplishing some kind of reform purpose. And what we see in New York, I just point out a couple of examples. In 1970, the state legislature passed the no-fault insurance law and also enacted something known as the comparative negligence law. And I'll talk about these two laws when we talk about torts later on in the course, but these two pieces of legislation, they really constituted significant changes in the common law. But on the other hand, what I will tell you is that there's still basic rules of law today, like the tort of negligence. If I'm careless, fail to act like a reasonable person, and I injure you or damage your property, you probably have a pretty good lawsuit against me, and that would be based on a rule of law that's never been explicitly enacted by the legislature, but as part of the common law, namely what we call the tort of negligence. A lot of contract law is still common law, or consists of a lot of common law rules, and the same could be said for real property. So I'm going to stop this screenshot video. It's a little bit short, but I want to have enough room when we get to something known as the model of judicial decision making, and that deserves about a 15-minute, which is about the max that I do with these. It deserves about a 15-minute time slot. So I'm going to end screenshot video 2, and that's really been limited to a discussion of the second way judges make the law, which is when they engage in the common law process. Thanks.